Testing. Good evening. And welcome to AARP Virgin Islands Say No to Probate, an inheritance planning workshop. My name is Linda Torres, and I am pleased to be here representing AARP, a nonpartisan, non-welfare organization that has been advocating for the needs of individuals 50 and older for the past 60 years and over 20 years here in the territory. AARP's mission is built around 3 pillars: health, wealth, and self. And today we are focusing on wealth, on the wealth aspect, specifically around probate and inheritance. Our goal today is to help you understand how to avoid probate when possible, and if necessary, how to reduce the complexities to secure your assets for your heirs. Here in the Virgin Islands, AARP has been advocating for probate reform for over a decade. We've supported legislation that empowers not only our 50+ members, but their families as well. Because as we say, what we do for one, we do for all. Some of our recent successes include passing the transfer upon death deed, guardianship and power of attorney reforms, and updates to electronic wills and notarial acts. But we recognize more must be done. Our current focus is on the creation of a dedicated probate court here in the Virgin Islands, one that could streamline this process, reduce backlog, and ensure Virgin Islanders secure their assets without the burden of delays or a costly process. Today's workshop is not only designed to provide you with practical knowledge and tools, but it is also part of an ongoing effort to help us fight for our elected officials to find ways to reduce the complexities of this process and to place this issue in the forefront in conversations about the future of this territory. As a quick reminder, while today's information is provided to you as a resource tool, we strongly recommend that when you plan to do your estate planning, you consult with your attorney or a legal expert for your family, okay? For those of you online, after each presentation, you can type your questions in the chat and your questions will be asked here in person. Now it is my pleasure to introduce our moderator for today, Attorney Jacanius James. Jacanius James. Thank you.
All right, good afternoon, everyone. First, I'd like to thank the AARP Director Toussaint Everett, Linda Torres, and Ms. Brady for the opportunity to be the moderator for you nice folks here tonight. Tonight we have a very diverse and experienced group of panelists. I would be remiss to not have them introduce themselves. So really briefly, if each of you can introduce yourselves to the crowd so we know who'll be presenting today.
Good evening, everyone. My name is Carl Purcell. I'm a local practicing attorney. I've been practicing since 1984, and my specialty is probate and estate planning, trusts, wills, things like that.
A pleasant good evening. My name is Nadine Marchena Ken. I am the Managing Director of the Virgin Islands Economic Development Authority's Enterprise Zone Commission. I'm also a historian and someone that has studied estate planning from 2 perspectives. One from the EDA side, as well as from the traditional genealogical and family history side.
All right. Good evening, everybody. My name is Kyle Sexos. I was born and raised here in St. Thomas, United States, Virgin Islands, 1985. A year after he started practicing. So I am very honored to be here tonight with the elders of the community. I'm flattered for the invite. When they tell me I come in to speak to the AARP, I say, I got the right person. What I could tell them, I need to learn from them. But in all honesty, what I do, I fix credit. I'm a credit repair specialist and a financial literacy advocate. So I'm heavy on understanding finance, understanding credit, and using credit to build generational wealth as to what we're going to all get into and talk to, and then, you know, how to avoid probate and all that good stuff. So again, I just flattered to be here. I feel like I'm amongst my aunties and uncles. I ain't gonna call nobody grandma in here because, you know, everybody young in spirit. So I just really, really honored to be here, guys.
All right, thank you very much for that, for introducing yourselves. So the theme of tonight, as you may have heard already, is say no to probate, right? So with the theme in mind, we're gonna start from the left and go right. Attorney Purcell, keeping this theme in mind and saying no to probate, can you please give the crowd your perspective from a legal perspective? Again, reminding the folks that disclaimer that this is not legal advice. But Mr. Purcell, from your legal perspective, how do we say no to probate, keeping in mind things like estate planning and some of the challenges that come with having to deal with probate, or the opportunities of not having to deal with probate, meaning planning your estate?
Well, sorry. I think that's a misnomer to say that no to probate. In the past, there was a backlog in probate, but over the past 6 years, a lot of that backlog has been reduced. And now, from my practice, within 6 months, I could get a probate from beginning to end in the courts. So while probate was a problem in the past, that problem no longer exists as far as I'm concerned. And probate is needed as a part of an estate plan because not everyone has the assets to create a trust. And you may have just a single asset that needs to go from you to your beneficiary, and the probate might be the best way to do that. So I will not eliminate probate and say no to probate.
Okay, but for those for those that would like to say no to probate, how would you
Okay.
have a folks go about it?
So there are different types of estate plans. You have the will, which must be go to probate. And then you have a trust, which most people are now doing. And then you have transfer and deed deeds. And then you have deeds of gifts as different options to probate. But in every aspect of what I have just said, you have problems and you have benefits. So I won't say one is better than the other. It all depends on what the person wants to do.
Okay, let me start circling back on some of those themes. Moving on to Ms. Ken, Nadine Ken. Tell us a little bit about the role of estate planning in wealth building in the Virgin Islands and some of the cultural nuances and relevance of estate planning that we have here unique to the Virgin Islands.
So from my perspective, and when we look back in history, I have a tendency to go back into our records here in St. Thomas, and I've seen documents handing over property from the 1700s, early 1700s. We're talking about people actually buying themselves out of enslavement and then immediately purchasing property and then handing that property down from generation to generation. Of course, at that point, many of them were intestate without a will, right? But certainly, even back then, we saw prenuptials that fathers would make sure that their daughters received, and made sure that the property that their daughters had would not automatically go to their husbands, because during that time period, the law said that as soon as I say I do, all my property went over to my husband. So these were things that documents were created to sort of protect the daughters, right? Certainly, sons were looking for wealthier people to marry. In more modern times, we look at right now where we have situations with abandoned buildings, and every one of you, as you drive through the territory now, not just in our historic areas, but throughout the territory, we have damaged buildings that have been left. Some people have been able to collect insurance and just decided, I'm not going to do anything to fix that building. And others who have passed and have not, their descendants, either one, don't know that they own that property, or that they could own that property, or two, think it's such an enormous problem that they're not willing to fight with their siblings, their cousins, and so forth to deal with. This is a thought that I want you to keep in the back of your mind. Every time you see me wearing red and white, or you remember this conference today, many people have owned their properties from Dean times. Families. Those individuals struggled to gain those properties. It becomes now our responsibility as their descendants to fight and hold on to those properties to hand off to the next generation. That is how you build wealth. I'm going to leave you with one example, and then I'm going to pass the mic for sure. But there was a lady who came over from St. Croix. I'm not going to name names, but came over from St. Croix during the late 1800s. Poor as ever. But she came over to St. Thomas in the upstreet area because she knew that there were opportunities for her to work. She worked as a co-worker. She worked cleaning homes. She worked and she lived in this building. And eventually she was able to buy the building. It was a long row house. She had 11 children. Her eldest 4 sons went off to the United States. Her grandson joined the military. One ended up in Wyoming. When we were asked to board up that building, because no one, somebody would come and pay the bill for the taxes. But when we were asked to board up the building, you said, well, we need everybody to sign off to give us permission to touch your building. Okay. We went and found that heir, the great-grandchild now in Wyoming. And they said, oh, we own something in the Paradise Tropical. Oh, they thought it was a millionaire building. Long row house, 2 rooms. We need to step forward because the liability was larger than the asset that existed at that time. But she worked so hard. Don't you want to show your ancestor, why your ancestor rolling over in her grave, right? Think about who you are and why you should be stepping forward.
Thank you. Thank you very much for that. Very, very insightful. Mr. Kyle Sexius, can you tell the crowd here today, so probate, again, keeping in mind this idea of saying no to probate. Probate can oftentimes be cost prohibitive, and maybe we'll get into some of that later. But can you tell us from a financial perspective, what are some of the strategies that the folks here listening in the crowd and the audience can use in this theme of saying no to probate, as well as the importance of doing so in building generational wealth?
Okay, gotcha. Again, I started my journey and the financial space in credit. And long ago, I ain't too sure how it worked. You know, I think back then you just save, you go and you buy your property, right? As time evolved, it got a lot, I guess, easier. I don't know if it's easier or simple. I don't know if to call it easier or not, because sometimes you go into these banks and these numbers and they asking for credit score and everything. It could be confusing, right? But nonetheless, there's opportunities now where you could use something called credit to purchase your house, to get approved for a loan so you could buy your house, right? And home ownership is one of the fastest and easiest ways to generational wealth, for a lot of the reasons that Nadine just explained. Because now, when we gone, we could pass that along to whoever we left it for. And then it's up to them to do the right thing to keep us from not rolling over in our grave. Don't sell your house and go buy a Civic, that type of stuff, right? So credit is very important nowadays, especially, and I'd like for you guys to leave this message with, you know, your kids and everybody else, because it don't stop with y'all. They have to continue building on what you guys left and what you guys worked so hard for. So it's up. They can't get comfortable and say, mommy and daddy do it, so I could cool out now. They have to continue adding to what mommy and daddy did. So as time passes and we start to evolve, they evolving also, and everything is just going and growing the way it's supposed to, as opposed to years later, somebody in Wyoming, or grandma leave me a house, or this house ain't what nothing, so nah, just leave it steady. And then grandma rolling around in that grave. So it's important for our kids, our descendants, to understand the power of credit, where we could use credit to get approved for house loans so that we could buy homes in paradise where we live. Because it's rough, because everything is expensive now, but it's a cost to live in paradise, right? So it's up to us to figure out how to navigate around those high costs so that we could stay in our homes, as opposed to, oh, it's too expensive, I gone from here. And then when we gone, everybody else coming in and there's nothing left for us. So really and truly, credit is one of the fastest ways to get you towards generational wealth, so that we could start building a foundation that we could leave behind for our kids.
Right. Thank you. Thank you. Sure.
I'd like to go back to what Ms. Machena said about abandoned buildings. From a probate point of view, a lot of buildings that come out of probate become abandoned because there are too many owners of a small piece of property, and people cannot agree among themselves how to manage the property, and it just stay there and go into disrepair. There's nothing wrong with creating a estate planning process where the ownership decreases instead of increases. So instead of doing tenants in common, there's nothing wrong with doing joint tenancy ownership, whereas a person dies off, the survivors take, and the ownership continues to decrease until one individual own the property. I think that's a better plan.
So in attempting to deal with that issue of estate planning and the challenges of the probate issue with the multiple ownership issue over multiple generations, the Virgin Islands Economic Development Authority sought a grant to deal with, to create a pilot program where if you were located or you had a building located within the enterprise zones and you had a multiple ownership issue over multiple generations, we would attempt to hire, if we could work with you, we attempt to hire an attorney to assist you in getting through that process. But you have to agree to provide EDA with information. You had to agree that you're going to work with your siblings or your cousins to get this program, to get this project together, and agree to share that information. So we're in that pilot stage at this point. We've already completed some of these types of pilot projects throughout the territory. And we're seeing success with that. You will start to see on our websites information about what they did to get through this process before they got to their attorneys, so that they had information to bring to their attorneys to resolve the problem.
I have a question for you, Ms. Ken, before we jump back to Attorney Purcell. So is it that with this program, how many of the individuals in the family are necessary to sign up? What if a family comes through the program, they'd otherwise want to utilize it, but they only have 2 of 5, or they only have 5 of 10? Are they still able to proceed with the program?
Yes, so we start off with whoever walks in the door. So if it's 2 or 3 of you that agree, part of this is maybe holding a family meeting. You may not talk to your cousin, the close cousin, you grew up together, but the mother passed and said, let them fight it out. We work with you because this is a liability right now. It's an asset. Yes, that building is an asset, but it's also a liability. If that falls down on somebody, let's say somebody breaks into the property and starts to live in the property, and then they fall down and they die in the property because they were squatting in the property, their family might sue your family. And they don't care that you are not talking to your sister, right? So think about how much it's going to cost you for not agreeing with your sibling. So we hold family meetings. You may never agree, but you agree that this building should go into an entity and be run by that entity. And then everybody, you may not talk to each other, but whatever is running that entity will then take care of that building. If there's 1 penny profit after the building is taken care of, you get your penny by mail, right? But at least you've dealt with the issue.
Thank you for clarifying. Attorney Purcell, before I move back to Mr. Kyle, you mentioned a few words that may or may not have gone over the head of some of us in the audience, and that is, can you explain to us tenants in common and joint tenancy? So in planning an estate, you mentioned an estate planner might want to consider either of those for various reasons. Can you clarify in layman terms, what do those mean?
Okay, so tenants in common involves when a person dies and or they own the property with another individual, and the person one person dies, their heirs come in to take their 1/2 interest if it's a half ownership. And so if they have like 9 children, each of them come in to take a 1/9 of the 1/2. So the ownership is growing, as opposed to joint tenancy. If the 2 of us own this property together and you died, and I own all by myself, because your ownership comes to me.
Right. And why would that be better for an estate planner versus the other one?
Well, with the tenants in common, the ownership is growing, and let's say you have to go to the bank to get financing, all have to qualify,
Right.
as opposed to the joint tenancy. If one dies, then only one person goes to the bank.
One person left. Okay, thank you for clarifying. Mr. Sexius, so you're dealing with credit and that being a good tool to sort of preserve and generate wealth. Sometimes, and Attorney Purcell can speak to this, sometimes folks die and they leave mortgages on real property. How would an estate planner sort of deal with this issue from a financial perspective, to the extent you said, the next generation needs to be financially prepared? Well, how can the person preparing the estate plan sort of account for things like this, if there's a mortgage, and whether or not the next generation will be able to?
That's a good question. So like the in-laws that say we don't want to hang our hat too high, but we could reach it, right? So if we do understand, we have to keep costs in mind. So if daddy and mommy is the only breadwinners, we're the only ones that's generating income that could afford this mortgage. If something happened to mommy and daddy, what little Billy gonna do? So we have to equip the next generation, get them ready to be able to generate the income that they need to sustain the wealth that you left. Because if your mortgage is $5,000 a year and you never encourage little Jimmy to better himself, go to school, go graduate, do whatever, Jimmy just living off of you, cooling out, going to the jam them and coming home whenever he feel like, and you're cooking for him and he hang over and you're bringing him tea. Then if something happened to you, Jimmy can't handle his mortgage, and then that's a problem. So it happens a lot, and it's common in this community where we so dependent on mommy and daddy. Mommy and daddy doing the right thing, but they ain't holding the children accountable. And we making sure that they do what it is they're supposed to do so that they could be in a better position, that they could succeed, because we ain't gonna be here forever. So we're doing them a disservice by not getting them ready. So the one way now, when mommy and daddy was financially successful for years, okay, you going college to be a lawyer, you going to the military, you going here, you going there. So now, if anything happened to mommy and daddy, we could sleep well knowing that the children are ready to take on this wealth that we left behind and preserve it so that we don't just got give it back to the bank.
Thank you.
From a probate point of view, and from my experience, I encourage my clients, when they have a mortgage on the property, to buy a life insurance policy, the value of the mortgage, so that if anything happens to you, it can be paid off and your descendants don't have to bear a burden.
Thank you. Thank you for, do you have anything on that, Ms. Ken? No? Okay. At this time, we're gonna open the floor up for questions from the crowd. So I know we have some folks online. Ms. Nisbet, are they ready for the phone? They are. Okay. All right. We'll take a question from the crowd.
And any of you guys can answer this question. So the first question says, can we hear about the transfer of deeds process? He would also like to know if whether or not a person can draft a transfer of deeds on their own from a template and submit it to the recorder of deeds without a lawyer.
That's a good question. That's the first.
Yeah, there is a format for transferring deeds. However, deeds are governed by the laws of the jurisdiction where the property is located. And if you're going to use a template, you must know the law of the jurisdiction. Otherwise, you could create a defective deed and not transfer title properly.
Can you repeat that last part? What's the implications of creating a defective deed?
The property is not transferred, and you end up have to go through litigation to complete that process.
Transfer. Is it
there are different kind of deeds. You have quick claim deeds, you have warranty deeds, deeds of gifts.
So I think, can you clarify, so the difference between, are you saying like a transfer on death versus a quick claim? What's the main difference between those two?
The quick claim takes effect right away with a transfer. Transfer on death takes effect when the person dies.
Thank you. All right, and we'll take a question from the audience.
Okay, good evening. Quick claim. Can you give a little information on quick claim deed?
With a quick claim deed. Hello? With a quick claim deed, you only transferring what you believe you own. You're not warranting that the title is good. So if I don't necessarily own a piece of property and I give you a quick claim deed, you cannot hold me accountable if it turns out that the deed was no good. No.
Can you clarify that last part? The question was, can it stand up in court?
No, if I go to court and I bring an action and say that you did not give me a proper deed and it's a quick claim deed, the court will say, well, that person was giving to you only what they believe they had. I am not warranting that I do own it.
Attorney Purcell, what does warrant mean for the?
Or does it mean that I can assure you that I own the title to this property?
So the next question online, I have a living will. Is this the best vehicle to ensure that my property and any financial holdings transfer directly to my two children?
Sorry, repeat that again?
It says, I have a living will. Is this the best vehicle to ensure that my properties and any financial holdings transfer directly to my two daughters?
No, you have a will, you have the trust, and again, you have a deed. A will, a trust, or a deed can do the same thing.
Attorney Purcell, on that point, can you clarify for the crowd the difference, the main difference between a will and a trust?
The will takes effect after the person dies. The trust is something that takes effect when it's made, provided that you transfer the assets into the trust. A lot of people have trust, but they never go the extra step of recording the deed, transferring the property into the trust. They didn't go to the bank and retitle the bank account into the name of the trust. And they did not provide for beneficiaries on the bank account. So if you don't do those things, you're going to end up right in probate that you're trying to avoid.
So just to clarify, does a will get you out of probate?
In order to pass the property using a will, you have to go through
You have to
probate.
go to, okay. All right, thank you. I have a question for Ms. Ken, and then I'm jump back to the crowd. Ms. Ken, can you help us understand, like, sometimes so did someone? Oh, sometimes here, in the Caribbean and other regions, we can have a bit of some cultural barriers is what I'd call it, or sometimes the family nuance of having created a will or a trust, or even having a discussion with between generations about doing that. What are some strategies you'd recommend I guess that would encourage people to have those conversations with their children or their parents, vice versa?
So one of the first things that I suggest to the children would be that you really need to not have your parents feel like they're going to die the minute they sign on that trust or that will. People of the Virgin Islands, people of the Caribbean, we are long-living people. And just because we sign a document does not mean that we're going to fall down the next day. That's the first thing. I think it's an important statement. It's supposed to, when you sign that paper and say, okay, Johnny gets this, Mary gets that, Lisa gets this, then that should take that weight and that stress off of you, right? The second thing is that understanding that culturally, children feel like if they're the eldest, they the ones that took care of the parents, and so they should get everything because I took care of them. They are the first. The middle child feels like, well, I didn't get a lot from the parents, so maybe it's my turn now. And then the last child may feel like mommy always took care of me. And so in death, our parents should still take care of me. And so where you think that siblings may get along with their parent and the parents see them when their parents are alive, you don't want to cause a chasm between, a split between siblings because of this property that you work so hard for. So parents of the Virgin Islands, elders of the Virgin Islanders, and I will even say now that youngsters are dying so early now, it's not time to wait. You're not going to fall down because you did this signature. You are trying to make sure to keep your family as one. And this is the way to do it.
Thank you. Thank you. Yeah, sure, sure.
I believe part of the problem with what you just said is in a family, and I know this from probate, you have a lot of children who believe in entitlement. I am entitled to this here because my parents give me so much when I was growing up, and they don't believe that they need to give to get anything. And that is a problem when it comes to probate and getting estates through the process.
Thank you. Kyle, I have a question for you, but I'm gonna bounce back to the audience and then we'll come back to you. So anyone online and then we'll do the audience. And then Kyle.
Okay, how many owners can you have on a joint tenancy?
Any amount, there is no limit.
Okay,
All right, quick. Audience, any questions?
Could I ask a question? All right. Angie and I have two properties and they're both in both of our names with joint tenants with rights of survivorship. Now, our daughter now is 28 years old and we would like to add her to those ownership. I guess that'd be through a deed. Correct?
Attorney Purcell, so how do we, the question is, how do we add a child to ownership that you currently have together?
Right.
Right.
But so that if either of us or both of us die, then Savannah can claim ownership without going through probate. Is
Probate.
that correct?
Okay, yeah, so the question is, two parents, one child, and you want to know how you can add the child to the property without going through the probate process.
Correct.
Once you pass, yeah.
So a husband and wife who owns property together is called a tenants by the entirety, husband and wife deed. If you add someone to that deed, you're gonna destroy the tenancy. You could retitle it as a joint tenant deed and add the individual, but then again, it will require both parties to agree to the retitling of the deed.
So both parties would be who? Who would need to sign the deed?
So it no longer will be a tenants by the entirety
Mhm.
deed, because only a husband and wife could have that kind of instrument. If you want to create a joint tenancy, then they have to do a new deed, creating a joint tenancy.
Adding the child to the
And
deed.
Yes.
Okay, now who would need to sign the deed of transfer? Just to be
Husband
clear.
and wife.
The two, okay, all right. And then I want to follow up on this question. Because people don't die in order, what are some of the concerns if the child predeceases the parents?
Then it goes back to the parents and the last person alive will take the property.
You're, no. So, so then would you recommend that format for any couple that wanted to add a child and, given the concerns?
You could do the joint tenancy deed or you could do a trust and make the child as a trustee.
Okay. Cool.
So I want to go back to the trust a minute. A lot of people are creating trusts, but there are going to be a lot of litigation with trust in the future from my perspective, because a trust is a private document. And one of the problems you run into is that the beneficiaries are not necessarily entitled to see the terms of the trust. It's only the trustee who controls the trust. And a lot of trustees are refusing to disclose to the beneficiaries exactly what are the terms of the trust. And the beneficiaries sometimes lose their interest in the trust because they don't know or they're not given information, and it results in litigation. And the process you're trying to avoid, you end up finding yourself right back into.
Okay, I have one in the back, one question in the back here.
Have a will and a trust and have language in the will to speak to who can and cannot in regards to the trust.
A trust has a will that is one of the documents of the trust, but the only purpose of the will is called a pour over will. And the only reason for having the will is that if you don't title the property into the trust, you could go into court and have the judge transfer the property into the trust. That's the only way the will is a part of the trust.
Can you speak to that in the will, that whatever is not left, is not mentioned in the trust automatically goes over into the trust?
So the will, beneficiary of the will, the pour over will is the trust, not an individual. So the court will pass the property into the trust if you didn't title it before you died.
You know, so,
Here's an example. So you have a situation where a person has written their trust. And the day before they passed, they bought a brand new Corvette. And then they passed peacefully. They were 99 years old. Right? But that excitement for the Corvette was there. So their trust said they have 5 children. This is what's going to the children. And the trust said, if anybody complains, they're out of the trust. They get nothing. Right? So I'm doing this for two situations, right? So the person went to a really good person to create, a good attorney to create their trust, so they have a pour over will. And they said the pour over will goes to Johnny number 2, right? That's going to get that, anything that was not in the trust will go to Johnny. So Johnny gets the Corvette. But Johnny complained and said, I don't like the fact that somebody else got the house. So Johnny is now out of the trust. Johnny does not get the Corvette. Johnny does not get the house. Okay, so certain trusts are written, and that is what Attorney Purcell was talking about. It's a confidential document, so all you see is only your line in there of what you get, right? So you know that your parents have a house up in Bon Esperance and another one out in Skyline Drive. And on your little line, you don't see house A or house B, right? And you complain, there's something probably there might be something in that trust that says, if you complain, you get $1. Then the trustee's responsibility is to give you that $1, right? At the same time, in a good, well-written trust, there's a pour over will. So that Corvette that was not expressly written in that trust was expressly written to go into the trust and given to a particular person. Ta-da!
thank you. Really quick, Attorney Purcell, can you clarify, because I know you mentioned litigation. So is it possible, because we're dealing with terms of trust, not to get too granular, is it possible to include language in there that does provide for some transparency? Meaning, if anyone in the audience is in that situation where they'd have more than one child or beneficiary, and they otherwise would want them to be able to understand what the terms were, is it possible to build that in to their estate planning so that folks are not fighting on the back end?
The trust has a provision that provides for the trustee to provide annual accountings to the beneficiaries. But if the trustee doesn't provide the accounting, there is no one to force them to do it unless they're going to court.
That's when you're in court. Okay, thank you. Kyle, so, and sometimes, the younger folks can feel like we have all the time in the world to get this done. With that in mind, what would you say, when is it appropriate time to start planning, wealth planning? Is there a particular age that you'd recommend someone start? keeping in mind things like retirement as well as probate, financial planning.
Yeah. Like Miss Nadine said, like, oh, like you say yourself, people ain't dying in order no more. Like my generation going faster than our generation. You know what I mean? So like, what? There's no better time than now. You know? If you start off, there's a lot of IRAs and different accounts and all these different money market accounts. Where if how much time we've been in a situation where all of us said, if I had started this when I had graduate school, if I had started this when I had my first job, how much money would I had at this age, you know? So the simple answer is no better time than now. If somebody financially, even if you get a little job and you point something aside, like is nothing is too little bit or too much. You know what I mean? Like I would definitely recommend any young person with any type of income to really start talking to, your financial advisors and everybody else to really start looking at putting things aside because especially the younger folks, because they're going faster than the elders nowadays. And it's unfortunate, But at the same time, it's not a game where the elders are the ones have to think about this because the elders are leaving and them type of thing. Like, no. Your son could go to the store to buy bread and two dudes arguing about whatever they're arguing about and he don't come home. So this is something everybody, we need to really encourage our kids to like start financial planning from now. Don't wait till you get older. You might not get older. And it's an unfortunate truth, but it's definitely something that needs to be said.
Thank you. Thank you. I will push that back to the online.
Yes, because they're eagerly asking. Okay, so the first question is, how does the bank respond to passing mortgaged house onto the heirs? Does the loan automatically transfer? If the mortgage is not paid, how does the bank deal with that?
I think we're asking, so someone's asking to repeat the question.
Oh, okay. Okay, so it says, how does the bank respond to passing a mortgage house onto your heirs? Will the loan transfer? If not, if not, how is the mortgage, if the mortgage is not paid, how does the bank deal with it?
If you're going through probate and the house was mortgaged, the bank will file a creditor's claim with the court to get the mortgage paid off in the probate process, or the court will pass the mortgage to the beneficiaries, and they have a responsibility to go into the bank and have the bank refinance the loan into their names.
Wait.
Good.
No, I have just a simple comment. It seems as if the trustee has total control over your trust.
That's why they are the trustee. They stand in your place once you pass away.
Suppose they're not good.
But
regarding the trust, you can appoint more than one trust. Trust doesn't want to do it and pass them. Okay. Oh, sorry. I said in your trust, you can actually put more than one person. You appoint a first, alternative, and a third. Secondly, somebody dies, have a mortgage. I work with banks. Okay? If they did not do anything, first person steps up to the bank and prove that they're related to this person, whether it be husband, wife, child, nephew, whoever, and they provide a death certificate, they have to complete the successor in interest process whereby they will provide the death certificate, the title encumbrance letter, and certain thing, and they'll be assigned to get information. But they cannot do anything with the property financially. They have to go through the probate if they did not set up their trust, okay, or if they didn't do a, they could have done a deed whereby it transfers debt upon debt. Okay, like I have a son, I could do a deed now, but he won't have no say in my property until I am deceased. Okay? He has that control. The bank would just acknowledge him as a successor in interest, but the mortgage would remain in the parent name. Okay? So if he wants it to come out of the parent name, he has to go and refinance the mortgage into it.
Thank you very much. We'll take one more from the online audience.
Hello? Yes, I'm glad
Right,
the
real quick, we're gonna take one more from the online audience.
Okay, so how is a trust originally created in the US treated when it includes Virgin Islands real estate asset? Will the property be able to avoid probate in the Virgin Islands?
Yes, a trust can be created anywhere, and then you bring the trust to the Virgin Islands and have attorney in the Virgin Islands review the trust to make sure that it complies with our laws, and that trust will be applicable wherever you go.
So they can avoid probate.
Yes.
yes, I'm
Alright.
glad the young lady comment concerning the trustee not being, for lack of a better word, no good. Is there such a thing as a trust and a living trust? And the reason why I ask, I know of a situation where a mother has her loving daughter, trusts her very well, decided to, my understanding, trust the property over to the loving daughter. But this loving daughter now have a loving husband who she so much believe in. He don't care to have her, the mother now, like in the home and wants to put her elsewhere, etc., etc. What would have been the mistake that she made at that time? Because it seems like she trusts the property over to the daughter while she was in good health, good mind, and all of that. But now it's like the mother is in the home, but it's like she have no right or no say. So what the mistake she made there is she should have put stipulation that she has to stay there, she can't take out, etc.
My advice to clients when they're creating a trust is you be your settler, creating a trust, and you be your own trustee until you pass away, and then it goes to your successor.
All right, Attorney Purcell, what is a settler of a trust?
The settler of the trust is the person who creates the trust.
Okay, and the trustee,
The trustee, the person who manages the trust. So my advice always to be your own settler and your own trustee until you are incapable to manage your own trust.
Ms. Ken, I have a question. So, I think generally the theme has been, how do we move on to the next generation? But sometimes folks may not have a next generation you can. Oh, guys, we're, if you can keep the volume, volume real quick, I gotta pose a question to Ms. Ken. So I was asking that sometimes the theme has been moving to the next generation, moving the property along to the next generation to avoid probate. However, sometimes folks need to estate plan, but they may not have a next generation to go to, or like this nice lady just illustrated, the next generation may not be so, I guess, inviting. So with that in mind, how can a family or an individual balance this wealth preservation, avoiding probate, with perhaps some philanthropic goals? Sometimes, folks just, go ahead.
Okay. So, and that's a great question. If you don't have any children, what do you do? If you don't have a fantastic niece or nephew or cousin that you don't feel comfortable giving to, there are lots of organizations that are there, nonprofits, who have live through the test of time. You don't want a new nonprofit that, you're not sure if they're going to survive, right? I would say that I have seen a lot of people leave their property to the government of the Virgin Islands. I have seen people leave their property to the government of the Virgin Islands. Now, the only thing I'm going to say about that is if you're going to leave your property to the government of the Virgin Islands, please don't leave it with a covenant that says, I'm leaving this to the government of the Virgin Islands, and I want a ballet studio built on it by the government of the Virgin Islands. And I want everyone to wear pink and black tutus while dancing in this building that the government needs to build on the property that I've left to the government of the Virgin Islands. There's covenants that have been placed on these properties that leaves the government in the Virgin Islands in a state of, okay, what do we do with this property? Because it's given to us with a covenant that we can't do anything else with the property. And that has happened for decades, hundreds of years almost, that have been left with these covenants that we can do nothing with. So be thoughtful, communicate, really important, communicate with the organization and understand that things in the future may not be the needs of today, but the needs of the future may be different.
Thank you. Thank you for that. I think a gentleman in the car had a question. Yeah.
Thank you very much. Good evening, everybody. My question is, there are difficulties associated with transferring a mortgage property into a trust.
Good question. Are there difficulties with transferring a mortgage property into a trust? Like, what are the challenges?
So when I'm creating a trust that involves a mortgage, one of the first things I do is I contact the bank and I explain to the bank that I'm creating the trust and I would like to get permission to transfer the property from the owner into the name of the trust. And the banks would give approval and the process will go forward.
Yeah. We'll take one from the online and then I have a question for you, Kyle.
Before you do that, I just want to make one comment. When it comes to trustworthiness of the trustee or even the executor in a will, I tell my clients sometimes when they describe their children, maybe you should let a younger one be the trustee or the executor. And a lot of Virgin Islanders are opposed to that. They always believe I should let the older child be the one who handles my affair. And you have to know your children. And that leads to a lot of issues because some elder child are undependable and you have to be true to yourself.
So to follow up on that point, what are some of the factors the folks in the audience should consider in designating a trustee? Sophistication, temperament?
How they handle finances, how responsible they are. Those are the two key things that go toward whether or not they will be responsible in managing the trust or in carry out the terms of the will.
What about their personality, their ability to manage personalities?
Yeah, if they don't argue a lot.
Great, but the audience.
Kyle, I think you might be able to answer this one. It says, good evening. We always see websites like LegalZoom for these kinds of matters like wills, trusts, etc. Do you recommend using such sites? And if no, why not?
LegalZoom, it's like so folks that don't know what LegalZoom is, it's a website that have like a bunch of lawyers, a bunch of legal professionals, and it's like a subscription-based website where you pay like $50 a month. And if you have any issues, you reach out to them and they would deal with you and sort out your issue depending on what your issue is. I've never used them before, but I more so like personal relationships. I like to know I could call my lawyer and be like, hey, I have this problem here. Can you sort this out for me? As opposed to me sending an email and then I gotta wait 7 days for some new lawyer to respond to me. It ain't the same one I dealt with last time. So I gotta explain the problem all over again. And he know what going on. And the one lawyer before, he tell me to do X, and then this lawyer telling me to do Z. So it's a matter of preference. Me, I prefer dealing with one person as opposed to a whole entity with a bunch of people. That's just me.
I want to also add that, as Attorney Purcell indicated, that attorney for legal Zoom could be anywhere, right? And the peculiarities of legislation here in the territory, even in Puerto Rico, is vastly different how they deal with estate planning. And so it's really important that you have someone in the jurisdiction that you're dealing with, and also that these attorneys here understand the cultural nuances that we may have that is not an issue in Wisconsin. I was going to say that.
Yep, go ahead. You can take, yep.
I guess it's on now. Good night, my name is Roger Minkoff, and I want to thank the AARP first for holding this excellent presentation. I want to thank the presenters for their expertise, and I have 4 topics that I haven't seen touched on, so maybe you can touch on them gently. One, that a trust can be a revocable trust, and can it be changed at any time? Topic 2, little discussion about the issues with and the probate process here in the U.S. Virgin Islands. I'm a real estate broker, and I know that there are 890 probates that have been running as long as 40 years. I just went through one with a client, and this is another topic. If you can touch on foreign wills with people who own property in the Virgin Islands and the process that has to go through that, which just took a client of mine 4 years. And then a topic that may or may not affect our immediate audience, but maybe our listening audience as well. And that is, could you just touch on Section 1031 of the US IRS Code and explain that so people know that way to tax-free wealth is through this Section 1031 of the IRS Code. Sorry for all that, but that's what we're here for. Thank you.
All right, I'll repeat that back. So we'll deal with them one by one. I'll bounce back from each one of those topics. So the first one I believe was, what is the difference between a revocable versus an irrevocable trust? Why would one choose one version of it or the other?
So a revocable trust mean the settler, the person creating the trust, can always change or revoke the trust before the person passes away. Irrevocable trust mean that once you create it, you can't revoke it. It's set in stone.
Yeah. Why would someone do either of those versions?
Instances where we have irrevocable trust is where the settler turns over the trust to another person to be the trustee, and they don't want that person to make changes to the trust. Revocable trust is when the settler keeps the trust and manages him or herself.
Now, in the revocable format, does the trust can the trust be amended after the settler dies?
No.
Okay.
At the point the settler dies, that trust becomes irrevocable.
Like the second one's quickly on the probate process. What are some of the timelines we're seeing and costs of probate?
Probate, the average time to get a probate completed is 6 to 7 months. And the reason being, when you file a probate, a creditor has 6 months, if it's a regular probate, to make claims against the estate. That's by statute. At the end of the 6 months period, you file what is called a final account, and you go into court to close out the estate. Estates, from my experience, estate that goes beyond 12 months is because the beneficiaries and heirs are fighting. Most of the time, they cannot get along. It's not the court process, but the lawyer is mostly the heirs fighting among themselves, or have disagreement or not cooperating with each other.
Um,
Good evening, everyone. First question, do you have any business cards at hand that can be handed out this evening? Attorney Purcell.
Well, I think the policy is that you cannot hand out business cards, but of course you have the names.
Okay. The next question, if you do get a life insurance for your mortgage, what is the procedure? Do you give the mortgage company a copy of that insurance? Do you also give it to your kids, or you can hand it, notify it in your trust or will in order for the mortgage to be paid upon your death?
So I would recommend you give it to who you name as the executor of your estate. And then that person name them and the policy and give them instruction to pay off the mortgage with the insurance.
Where should the instruction be? Should it be in the trust or?
It could be in the trust, it could be in the will, but I mean, you need to inform the person who you're gonna name as the beneficiary of the policy, what your plan is.
It goes back to the same question asking of trusting the person who you put in charge for your will or your revocable trust. The question why was asked that, because if you do have a life insurance to cover the remainder of your mortgage and you notify the bank that you have the mortgage with, if you do it a different way that the trustee would have control over that money can be squandered. Going back to what Mr. Sextus was saying about we not giving our children, telling them how to build wealth. They can squander that money. So that's why I'm asking the question, do we notify, even though we put it in the trust, shouldn't we still notify the mortgage company or the bank that we do have an insurance that will cover the remainder of that mortgage?
So then maybe what you would do is, in the insurance policy, you name the bank as the beneficiary.
I think we had another question. Okay, so I'm gonna shift gears a little bit here, and then I'll come back to Roger, your other comments. So right now, Merrill Lynch, well, it's a financial institution based in the United States, as well as WeForum.org, is estimating somewhere between $8.4 trillion in assets that will pass from the current generation, that those are your boomers and older, to millennials and your Gen Zs. That is a substantial amount of wealth that be transferred in the next decade or so. So my question for Mrs. Ken and Mr. Sexius is, how, in your opinion, does that transfer of wealth going to impact the economic stability of communities?
The transfer of wealth from this generation down, it depends, and it all leads back to what I was saying earlier, man. Everything starts in a household. We have to really, really bring up our children to be financially responsible, to understand the importance of a dollar, to be financially literate, to understand what builds wealth and what doesn't. Because if we don't do those things and we just transferring them all this money, what I think they're gonna do? They're gonna just squander it. You can imagine working for 30, 40 years to build this house, and then you pass away, you leave it to your son and he sell it and buy a Lamborghini. Like, so it all depends. But say one, say two, this new generation, we have access to a lot more information than the generations before us. So a lot of us are taking the responsibility to become more financially literate. But it always helps when the parents give them that extra boost. Like, yo, make sure when I leave you this, you do what you're supposed to do with it. So to answer your question, the economy is going to boom for sure, but it depends on how you raise up your children, what they're gonna buy. If they're gonna invest in properties and wealth building assets, or if they're gonna blow it. So it all depends on the kind of children you have and the environment that you guys set for your kids.
Ms. Ken, real quick before.
Certainly, I want you to think, when you ask that question, everyone here who has grown up in the territory remembers a time period when they say home, they understand what home means, right? As you pass these monies on this wealth on to the next generation, I want us to imagine a place where we don't have abandoned buildings, where our young people who may be globetrotters, they travel the world, will find that this is home too because they have some place to come home to. When you pass that wealth, even though they may not own it, their cousin owns it, and it's a family understanding that it will be a different place. But it will be a place that we still can call home. And I think that's an important understanding, that you build wealth and these people will be proud wherever they are in the world to say, yes, I'm from there. And so that passing of wealth means a passing of pride and an understanding of who they are in this world.
Thank you. We're gonna field the questions on the online. Are they off?
Yeah, we'll be back.
Okay, all right, we'll jump to the crowd then. Any questions? Oh,
Can you give us a ballpark figure as to what it costs for a will versus the trust?
To prepare a will is $650 roughly. And to prepare a trust is like 3,000. When you pay the government costs of recording the deeds and the average attorney's fee is like $2,500.
Attorney Purcell, can you give us a range? Like what?
Wait.
What is
I want to add to that question. You spoke about how much it costs to prepare. Okay, now the person has passed and the person is trying to deal with it. What is the cost of dealing with a probate versus dealing with a trust?
Probate averages around $7,500. So, but the asset already is for the beneficiaries to pay for that cost, as opposed to the settler who is creating the documents. Okay, I create a will for $650, but why should I pay for my children to probate the estate if they're gonna inherit something of value? That should be their responsibility.
And I want to say this to everybody because I've gone through this with people. If you're going to create a trust and you have these trustees having to do some work after the fact or will, I think you should build into it because a trustee might just not even be someone who's getting anything. They might not be a beneficiary. They might just be a trustee. And there's a cost to doing everything. And I would say build in that money to implement. It's at the end, so it's cheaper or less expensive to do a will in the front end and more expensive to do a trust in the front end. But in the back end, it is much more expensive to do a probate with the will than it is to implement a trust. Correct? I'm not an attorney. I want to make sure that that's clear.
I'm gonna jump back to two of the questions Mr. Minkoff had. Can you, commonly in the Virgin Islands, some Virgin Islanders may have issues in Nevis, in Tortola, in the US. What are the implications of a foreign will in the Virgin Islands? How is that treated here?
So once the will has been, I guess, brought to the probate court in a foreign jurisdiction, you bring the exemplified copy of that will to our jurisdiction, and you do what is called ancillary probate, where within 30 days, if the court admitted to probate, you could get the process completed, basically, relatively simple.
You do, okay.
Which transfer of deeds is most successful in the territory?
Can you repeat that?
Which transfer of deed? I'm guessing there's multiple options, but which option is most successful in the territory?
Most successful.
I'm guessing they're trying to figure out which one is the easiest process, which one is most least cumbersome. Guessing.
I would say a deed of gift is the simplest way to transfer the asset, as opposed to doing a warranty deed where you warranting the title to the deed.
Now, you said deed of gift, is that a deed of gift subject to life estate or just a deed of gift on an outright transfer?
Well, all deeds are subject to life estate if the grantor includes that language in the deed. During their life, the grantor retains possession of the property. And on the passing of the grantor, you record the death certificate and the grantee takes full title to the property.
Okay. I think we're gonna take one more from the audience and then jump, sorry, the online audience, and then we'll jump over to this gentleman here.
So trust versus probate. What are the real pros and cons?
Okay, the pros and cons of a trust versus probate.
Okay, so a trust consists of a series of documents. You have the trust, the declaration of trust, the certificate of trust, the warranty deed, the pour-over will, the financial power of attorney, and the healthcare power of attorney. Those are the documents that encompass the trust. A will is just one document. So with the trust, you have the financial power of attorney, which the grantor names someone to manage their affairs financially if they're incapable of doing so while they're alive. The healthcare power of attorney names someone who will make your healthcare decision for you if you're incapable of doing so. And the certificate of trust and the declaration of trust. The declaration of trust is the private document of the settler giving instructions as to what should happen with the assets. That document you don't share with the public. The certificate of trust is a summary of the declaration, and that is the document that the public sees most of the time.
Thank you. This gentleman here. If you can get a mic real quick, sorry, a mic.
Good evening, thank you. Are there tax implications for the deed of gift?
No, not I'm aware of.
So there is what's called an estate and gift tax. Right now, the current exclusion is 15,000 a year. The lifetime exemption is somewhere around 13.1 million. So meaning anything over that, then you're running into estate tax issue. But I mean, that may or may not apply for some people in the room, but it's a large gap there before you start running into those issues. But not in the Virgin Islands. Virgin Islands law does not assess a gift tax. That's more of a federal issue. Online, do you have any questions online?
Yes. Okay. Can I gift my children property or money without them being taxed?
Can you repeat the question?
Yes. Can I gift my children property or money without them being taxed?
Without them being the children?
Yes, without them being taxed on the gift and the property.
So I don't think we have an inheritance tax in the Virgin Islands.
No, so I'll repeat again. So The gift and estate tax is part of the federal regime. The Virgin Islands does not assess a gift tax on transfers. So if you were transferring property subject to a will or a trust, there's no gift tax that's assessed here. You may run into issues to the extent of a very large estate, that's $13.1 million. That's when that gift and estate tax starts becoming an issue for most folks. I'm gonna jump back. Mr. Minkoff, you had a question about 1031 exchanges. I'm gonna field that to the entire panel. Any comments or perspective on 1031 exchanges as a financial planning or estate wealth building tool?
That's when. So from my knowledge, that's when you pass away and you pass the house over to your no. 1031 is when you buy a property and you trade it for the next one. Yes. All right, what was the question about 1031?
Well, how can that be utilized to sort of preserve wealth, or is that a good estate planning?
I mean, it's a good way to not pay taxes, and to not pay taxes is a way to build wealth. So if you, instead of selling this property, when you sell this property, when you 1031 it over to the next property you're about to acquire, then whatever the taxes were that you were going to pay on that property, you don't have to pay it. Am I wrong? Say that? It's deferred. So if your children sell the house, then you pay, right? Am I wrong?
Anyone else
feel free to
any
chime in.
comments on 1031s?
Well,
1031s.
I mean, give this man the mic because clearly he knows. So help us out with the 1031.
Thank you.
Thank you. Close but no cigar. People can look up and Google US IRS Section 1031, and it will give a definitive explanation. But basically, it's what's called a like-kind exchange. Broken down in this sense, you bought a property for $1 million. You put $250,000 into the improvements. You then sell the property for $2 million. The IRS calls the profit of the $750,000 booty, like pirates' booty. If within the limited time that you have, you purchase another property using the booty, the 30% capital gains taxes are deferred. Then you buy another property and you do the same thing and keep rolling it. And basically you end up never paying the 30% capital gains taxes. And that in real estate is the tax-free wealth that you can grow.
Gotcha.
Thank you very much. If I'm not correct, 1031s are good on investment property, though. You have to hold them as an investment property. Are they use them for residential as well?
You can use it for any kind of property as long as it's a like-kind exchange, as in real estate for real estate, yacht for yacht, like-kind exchange.
Thank you. Thank you.
Yeah.
I have one question. I'll jump back. I have one question here that came in from an individual that just didn't want to see that speak in the mic. I have two brothers own property. They're now deceased. One of the brothers had a will and a trust, but he neglected to mention the property he owned in that will and trust. The trust indicated that anything he neglected to mention in the will or trust should be included, should not belong to probate. How would the courts handle that issue?
So in a will, there is something called a residuary clause, that anything not specifically named will go to the individual name in a residuary clause.
Attorney Purcell, what is a residuary clause?
So it's a clause in a will, it's like a catch-all provision. stating that if I haven't mentioned something in this will and it come to be owned by me, then it will pass to specific individuals.
All right, I think what are you doing?
Right. So just to be clear, I'm guessing this is a follow-up. If you create a trust the correct way, does that mean you completely avoid probate? No 6-month waiting period?
No, you could have created a trust with everything done correctly and you pass away and then you come to realize that you own a piece of property or you inherit a piece of property, then you still have to go through probate to pass it into the trust.
Okay. And then I have another question. Oh. Do you want me to say the question again? I think they didn't hear it. So they said, just to be clear, if you create a trust the correct way, does that mean you completely avoid probate?
And yes,
So yes, you avoid probate.
you avoid probate if you did it the correct way and there is no other property out there that you did entitle into the trust.
All right, do you have any questions in the audience?
Good evening. So I heard you said in terms of the trust that if you somehow come into property that you did not name in the trust, then you may still have to go through probate. But I thought that that was the purpose of the pour over will, that any property that, you know, was not specifically named could either be part of the residuary clause or, you know, would eventually be part of the pour over will.
So even a pour over will has to go through the court process to pass the property into the trust. That is the probate process.
I'm gonna piggyback on this question. So in describing the difference, you know, when a person drafts a will, Attorney Purcell, what have they done with their interest in the assets in the will? Has a transfer occurred?
The transfer could only occur by the court probating the will. It is not an automatic process that I create a will and the properties transferred on my passing automatically. Only the court could do that.
And versus a trust, does a trust transfer the interest?
The trust is a different process. Once you record the deed, the transfer takes place automatically. Then and there, not later on when you die.
This question is for Ms. Ken and Kyle. Inheritance planning. How does inheritance and financial planning address or avoid wealth disparities in communities?
Ask the question again, please.
So wealth disparities. Sometimes we're in communities where individuals are experiencing large, I guess, gaps in wealth. How would inheritance planning, if it does at all, address some of those issues of wealth disparities in communities?
So we have situations where people have a home or have something that they don't think is very valuable, right? But the passing of that on to the next generation could fill that gap. You may have a checking account with $5,000 in it that you have been building up slowly, and you think that's not a big deal. But that $5,000 given to your granddaughter, right, could help them do a down payment for the VI Slice program to buy a home. I want you to think through that these small little things can step the next generation up into an area that you might not, you've always rented your home, you have not been able to purchase a home, but you have that $5,000 that you've saved forever. You've been adding to it. That can help that next generation with a down payment to help you with VI Slice. VI Slice is a program of the Virgin Islands Economic Development Authority. Your minimum down payment that you could make, that you have to put skin in the game, $5,000, right? And then good credit, right? The ability to pay back a mortgage all comes into play. But the first thing you have to be able to have is $5,000 cash to begin with. And then your credit, then the ability to pay back and so forth, right? So see how that little bank account could help the next generation. They could own a home and they could pass that home on to the next generation.
Yeah, just to piggyback off of that, if you happen to own a home in a not so good neighborhood in your mind, right? My mother would tell you, like, and she here in the audience, she ready. Mommy. My mother would tell you, like, she's a Savanero. She was born in Savan. My grandfather, Savaneros. What houses were going for in Savan back then? Going for a lot more now. So, you know, if my grandfather were able to pass along a piece of a 1-bedroom, 2-bedroom in Savan to my mother, and she passed it on to me, 2 generations later, that house worth a lot more than what it was worth then. But if my grandfather had the thought process that, this is just a little shack, man, I ain't want to leave this to nobody, then I have nothing to build on. She have nothing to build on. So no matter how small it is and how small compared to anybody else, don't worry about what them other people doing. Worry about what it is you could do and what it is you working on. And it's nothing too small to pass on to the next generation that would not be helpful to help them towards their financial journey. That's my thing.
I also want to add, I mean, I've written a paper on the history of Savan from the very beginning, 1672. I see people now trying to buy property in Savan. People who have never heard of Savan, they have no idea what Savan is about, why Savan was the go-to place, or what makes Savan special. They see an opportunity. So your grandfather passing it on to your mom, and maybe she'll pass it on to you. Maybe she might adopt me.
Once she don't pass it down to her boyfriend, we good.
That is something that I want y'all to think about, right? That this neighborhood may be going through its throes, but that other people are looking and other people are considering it. Right?
Just to piggyback off of what Nadine said, I went to a restaurant on Main Street the other day, and I sit down eating, and my waiter come, and you know he's serving us. He's a Caucasian member of the LGBTQ community, right? And he, you know, serving us, nice guy. It's like, man, I was like, this food is really good. And so he talking to me, asking me where I'm from. I said, from right there. What about you? Well, I'm from Wisconsin or wherever he was from, but he loves the island so much and da 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 da. So I said, okay, cool. He said, yeah, I don't have a car. I said, really? How is that working out being in St. Thomas? You don't have a car. How do you get to work? I walk to work. I said, where you live? Oh, I live in Savannah. So I'm like, oh, you live in Savannah, my boy? So think about how far we've come where a Caucasian LGBTQ person could live in Savannah and walk to and from work every day with no care in the world. So if I get property any place on this island called St. Thomas, it could be in the bush, it could be Peterborough, it could be Savannah, not sure it. Because where it was today, tomorrow it could be worth much more.
So at this time, we're gonna wrap up. I'm gonna give each of the panelists a few seconds to sort of give some final parting comments to the crowd. Okay, really quickly, because we're running out of time. Mike.
You mentioned VI slice. My daughter went to apply and she was turned down because she is part of an estate trust where I am the trustee. And my mother leave a property for 1/9% of that property. She leave it for 9, including her 7 children and 2 grandchildren. She's one of the grandchildren. And she was turned down because they claim that she owned 1/9 of that. Is that correct?
So very quickly, I know we're running out of time. The VI Slice program is a program that the Virgin Islands Economic Development Authority has. We do it with federal funds, and these federal funds, as one of the parameters, and there's several programs that are helping you to buy your first home through Housing Finance Authority and the VI EDA. And one of the criteria is that you own nothing. It is not our rule, it is a requirement in which we have gotten these funds so that the individuals can purchase something from the very scratch. And the potential for them to own 1/9 of something means they own something, unfortunately.
Real quick, in the fire chat, wait, any closing comments for the audience? Audience, real quick, we're gonna wrap up and have some final comments before we end the program. All right. Whoa. Push it up, yeah.
I just want to thank you for inviting me to be here tonight. I just want to close with one final comment. Make sure your bank accounts are not an account as opposed to or accounts. An account is going to cause you to go through probate as opposed to an or account where the successor owner takes all.
He was talking about bank accounts and doing or instead of doing and when 2 persons' names are on it. My final comment is, I have 2. One, we do have that pilot program. We are still looking for a few good candidates for that program with regard to estate planning. And the other one is, my thoughts are, we ask you to do something. Don't come, and you've come here tonight and spent time with us and then go home and forget. Please, I'm asking you to take action. I'd like to thank AARP for inviting me to speak with you today.
All right, my final comments is expect better from our children. Be hard on them. No matter how old it is, they still our babies. Be hard on them because I work too hard. I work too hard to leave them while leaving them for them to squander it. Okay? So financial literacy is important. They need to understand the importance of a dollar. Teach them that. I know a lot are in here frugal. No, a lot are in here financially responsible. So drill it in them children head. Because when are you gone? There is what left in this world, to represent you guys. So drill it in the head. If they complain and say, mommy, you're annoying, I don't care. This is stuff you need to know. Tell them get a credit fix. Tell them understand what's important. Tell them how important it is to build generational wealth and follow the footsteps that you guys, showed them. I want to thank AARP for bringing me here. I learned a lot today. I don't know why. I feel honored to be here because, like, man, I learning. They're asking questions that they give me the mic. No, you answer that. So this was very informative, and again, man, I just pleased to be around my elders of the community, as my aunties and uncles, and I love all of you. And thanks for having me, man.
And a round of applause for the panelists. I just have my final parting words to piggyback off of what Ken was saying. I don't know if any of you have seen a death certificate. I tell clients all the time, we all have a date, right? We're not gonna get around that. We all have a date. And so I too would encourage you to plan your estates. Don't leave here and just, have it go to the wayside. Take the time to reach out to your financial and your legal advisors, through the resources of the AARP, but the Bar Association also is there to provide those resources for folks that are interested in getting their estate planned.
I want to
Thank
add one last thing. Attorney Parcell say, the reason the probate will take as long as it take, ain't because of the courts. It's because our children fighting. While are you here, sit down with them? Talk to them, explain to them the bigger picture. This ain't about you, Susie, or about you, Jeff. It's about all of us and our name living on. And if you can't get along, then everything we done, everything I've done, everything I worked for was in vain. Because who is it benefiting that this property that I leave for you sitting down in the courts for months and months and years? Because you don't get along. So just sit down, have a family meeting with everybody, and just sort it out, man. We's a family, and that's all I got to say, guys.
So I guess I get the last word. The grant that we have is sponsored by the Department of Interior. It's sponsored by the Department of Interior, the federal government. Part of what we do is have family meetings with you. If you don't talk to your sister, your first cousin, and you own a joint property, please call us.
All righty. Thank you so much. Wonderful, great, and awesome panelists. Thank you so much. For those of you who don't know, my name is Pamela Toussaint, and I'm the Associate State Director of Advocacy and Community Outreach for AARP in the Virgin Islands. And this honestly has been an awesome, I'm saying, I'll use those words to describe this informational session. But I think one of the biggest takeaways is this: do not leave here and just say, oh, this was a wonderful conversation that we had, a great discussion. We really want you tomorrow, get on that phone, even tonight, have those conversations with your kids, have those conversations with your neighbors, have those conversations with your husband, have those conversations with your wife, and do it. And do it. I myself was in a predicament a couple years ago where I'm, again, the Associate State Director of Advocacy, and my mom went into a diabetic coma, and I stood in that parking lot of the hospital saying, wait a second, we don't have a will, we don't have a trust, we don't have an advance directive. The very next day, I contacted our legal counsel and we got a trust together. You have to do it because you don't know the time, nor the hour, but the one thing that is promised is that we will be passing from this earth. Don't leave these things I know Attorney Purcell mentioned the fact that, it's not so much the courts, which is true, but I will tell you one thing. Last year alone, the courts ended up with closing with 865 pending probate cases in the territory. If you equate that with just an average of how it can go up to 100,000, 200, 300,000, there's so many people that are not benefiting because there's 800 plus probate cases pending in the territory. Don't add to that number. Do what you have to do as a family member. Do what you have to do as a Virgin Islander. Create that legacy, protect your legacy, and protect your heirs. There's no reason why we have to have attorneys and those flatter attorneys or anyone else decide our fate. We need to take matters into our own hands. And that was really one of the reasons why AARP wanted to make sure that we put on this informational session, that we equipped you with the resources and the information that tomorrow, not even tomorrow, tonight, when you leave from here, have these conversations. I know it's a very difficult conversation. It's a very uncomfortable conversation to talk about that. We don't do that well in the Caribbean at all, but we have to. We have to do it for our heirs. We have to do it for our caregivers. We have to do it for ourselves. This is our legacy. This is our home. And no one else should inherit what is rightfully ours and what you work so hard for. So again, thank you so much for coming out. To my panelists, Thank you, Attorney Purcell. Thank you so much. Ms. Marchena Ken, thank you. Mr. Sexius, thank you for really giving us a true perspective on what and the importance of inheritance planning and estate planning. And to you, the audience, online, as well as here, thank you for coming out. This is not going to be the last time that we put on this informational session. AARP is here to empower not just the 50 plus, but all Virgin Islanders. And if you're interested in learning more about what we do, you can contact us via our Facebook page, one, but and also too on our website at www.aarp.org/BI. And you'll find out all the great things AARP is doing. We're fighting for every single Virgin Islander. And there is a misnomer that you start at 50, or it's just for 50 years old, Virgin Islanders. Actually, you could become a member of AARP as young as 18 years old. But seriously, thank you so much again. And to my awesome volunteers, I could not have done this without you. Thank you, thank you, thank you. Omari and his team for making sure that we're able to broadcast this, and the university for giving us this wonderful space, my alma mater. But again, thank you so much. And again, don't just leave here with all of this great information. Really, truly do something about it and protect the legacy here, protect your legacy here in the Virgin Islands. Huh? And I cannot forget the awesome moderator, Attorney James. You did an awesome, awesome job. And so the next time we're gonna actually have him as one of the panelists. So you've already secured a position with us. But no, again, thank you so much. And we do have some refreshments, so please join us and look out for more information about AARP in the Virgin Islands. Thank you.